Well, good evening, everybody. Just to highlight a couple of things before we get going. First of all, tomorrow evening, a bit earlier, at 8 o'clock my time, looking forward to having a chat with Sharon Sunshine, to do with the 24-hour streaming of Erakozy videos. Monday, as usual, it'll be myself with Dr. Silkman, hopefully catching up with Mill Billy at some point, depending on his work schedule. And then next weekend, at some point, Tracy Keogh has agreed to come back on and do a bit more chat with me. As a lot of you will know, I believe it's exactly a year now that Stephen Drizzen and Laura Nyrider wrote on behalf of Brendan to Governor Evers asking for clemency, and still haven't really received an answer from Governor Evers himself. Hello, Alice. Hi there. I realise it's a bit late this evening. It's quarter to 11 my time, but StreamYard didn't reset until about an hour ago, even though it was supposed to. Well, the 1st of October for me was 22 hours and 46 minutes ago, but it was about an hour ago that it reset finally. So here we go with the next part of the motion from Kathleen Zellner. I've called the video unprecedented corruption because, as we've discovered, what Ghan, Fallon and Wiegert got together and did, there's never been a case like it before, at least not one that's been exposed the way that this one has. And in fact, one of the things I have tried to do is see what sort of punishments should happen to Wiegert, Ghan and Fallon. But I think they would be facing charges over due process. But here's hoping it's far worse for them. Anyway, let's crack on then with the... let's go back a paragraph from where we left off. So 48, a violation of the DNA preservation statute constitutes bad faith, which you can't put it much stronger than that, although I can think of a few ways of putting it stronger, but that's legal term for very, very wrong. This conclusion is not undermined by the Wisconsin Court of Appeals' adoption of the official animus standard in Greenwald. The Greenwald Court emphasized that bad faith does not exist when the destruction of evidence was due to inadvertent or negligent actions on the part of law enforcement. However, this exclusion only pertains to two situations where evidence preservation was, one, required by non-codified law enforcement agency policy, or two, not required by any policy. Mr. Avery submits that a violation of state law goes far beyond the negligent standard that the official animus framework was formulated to replace. That is, a violation of state law should not be analyzed within the context of mere negligence or inadvertence. Indeed, such a violation should immediately trigger official animus as adopted in Greenwald as a per se showing of bad faith under Youngblood. Additionally, the state acted in bad faith where it was on notice that the trial court had ordered preservation of certain items of DNA evidence, yet proceeded to effectuate the loss of biological evidence within its control. On April the 4th, 2007, the trial court entered an order for the preservation of blood evidence and independent defense testing. This order contemplates and allows future DNA testing by Mr. Avery. In its order, the trial court gave Mr. Avery the opportunity to, at any time, submit items of evidence for DNA testing. It is clear that the parties have broadly construed the scope of the April 2007 order to permit testing of a variety of biological samples deemed relevant to the instant case. The state was on notice of this agreement in September 2011 when it facilitated the destruction of suspected human bones recovered in the Manitowoc County gravel pit. That the state knew it bore a duty to preserve biological material at the time it facilitated the potential destruction of the suspected human bones without notifying Mr. Avery and his attorneys. The state, by taking these actions, acted in bad faith and with official animus as defined by Youngblood and Greenwald. United States versus Ball, finding bad faith where government actors destroyed potentially exculpatory evidence when they were on notice that the evidence at issue should be preserved. And again, United States versus Cooper, finding bad faith where law enforcement agents destroyed evidence they knew the defendants asked to preserve. Application. Now, the presumptions created by the DNA evidence preservation statute shape the analysis that Wisconsin courts should undertake when confronted with instances such as in the instant case where a law enforcement agency violated the statute. This analysis is grounded in the two-part test set forth in Greenwald. However, it differs to the extent Wisconsin courts apply the presumptions created by the DNA evidence preservation statute. These presumptions, as set forth above, dictate issues at the heart of the test. As described more fully above, the first step in the Greenwald analysis is an inquiry into the first two steps of the Trombetta test, whether the destroyed evidence was apparently exculpatory. This examination asks whether, if the destroyed evidence was subjected to testing or retesting, favorable results would exonerate the petitioner, and whether the state was on notice of this fact. If the state failed to preserve evidence that was apparently exculpatory, and if the state was aware of its exculpatory nature, then the court must vacate the conviction. If, however, the evidence is not deemed apparently exculpatory, then Wisconsin courts should apply the Youngblood test under the second step of the Greenwald analysis. Under the Youngblood test, courts would examine whether the evidence was potentially useful, and if so, whether the police acted in bad faith when they destroyed the evidence. In light of the presumptions created by the DNA evidence preservation statute described fully above, the evidence must be considered potentially useful. Next, the court considers whether the law enforcement agency acted in bad faith. As set forth above, the presence of bad faith is presumed every time the DNA evidence preservation statute is violated, because such a violation means that a law enforcement agency acted outside the scope of its normal practice by destroying evidence it knew had to be preserved in compliance with Wisconsin law. In the instant case, the suspected homes are potentially useful, meaning that retesting of the suspected human bones from the Manitowoc County gravel pit could demonstrate Mr. Avery's alleged actual innocence. It is indisputable that the state violated the DNA evidence preservation statute by returning the suspected human bones to the Holbach family. Mr. Avery's due process rights under Youngblood had been violated. According to federal and state due process jurisprudence regarding the state's duty to preserve evidence, the appropriate remedy for a violation of Wisconsin's DNA evidence preservation statutes is the reversal of the criminal defendant's conviction. Therefore, the case should be remanded to the circuit court to conduct proceedings to determine if there has been a due process violation and how that violation should be remedied. Mr. Avery has brought this issue to the court's attention in a timely manner. He does not want to waive this issue by not addressing it at this time. The appeal must be stayed and this issue must be remanded to the circuit court for proceedings that should include a hearing in which Deputy Jeremy Hawkins, Sergeant Investigator Mark Wiegert, Attorney Thomas Fallon, and Attorney Norm Ghan would be subjected to cross-examination concerning the illegal transmission without notice to Mr. Avery's prior counsel and the presumed destruction of the Manitowoc County gravel pit suspected human bones. The undisclosed September 20, 2011 report contradicts Mr. Kratz's representations to the jury that these bones in the quarry, I'm going to take 20 seconds to talk about because the best anybody can say is that they are possible human. The state, by its actions, has implicitly admitted that the bones are not only human, but that they belong to Miss Holbach. The state cannot credibly argue that it returned animal bones to the Holbach family for burial or cremation. The state's actions demand that further proceedings be conducted to determine if Mr. Avery's due process rights have been violated and if the state acted in bad faith in returning the suspected human bones to the Holbach family. Finally, confusion. Wherefore, undersigned counsel respectfully requests that this court enter an order staying this appeal and remanding the cause to the circuit court for proceedings to determine whether the state has violated Wisconsin statute 968205 and Youngblood versus Arizona. And there we have the two signatories. And I think after that, all that's left are the exhibits that were posted. And of course, it's not difficult to see how they acted in such bad faith. This evidence was meant to be preserved. If there was any intention of handing it back, then Stephen Avery, through his attorneys, should have been notified. And had there been a question about that, so Stephen Avery would have presumably have said, well, yeah, there's a problem here because if you want to hand them back to the Holbachs, you're admitting that they are Teresa's, and obviously would not want them being handed back, but being tested, or at least that being part of his appeal process at the time. As I say, the fact that the state are doing it secretly behind backs, in any other disputed case of handing back the evidence, if there was an argument about it, it would actually go in front of a judge. These characters have bypassed everybody who has got an interest in these items. Let's just, for the record, read what Hawkins wrote. Return items, 20th of September 2011, so just over 9 years ago. At approximately 9 o'clock, Jeremy Hawkins, Mark Wiegert, Thomas Fallon, Norman Ghan removed from evidence all property tag numbers that contained human bone. Ghan and Fallon reviewed the items under the property tags and, along with Dr. Leslie Eisenberg's report, determined which bones could be returned to the Holbach family. Tag number 8318, contents sifted from Steve's residence, the burn pit. The human bones from 8318 were removed from the container and photographed. Property tag 7924, an unidentified material suspected to be bone, and 795, unidentified material charred were removed and photographed. 7936, unknown material suspected to be bone, property tag 79, bone fragment, and 7944, bone fragments were removed from storage and photographed. 8675, the human bones were separated from the rest of the contents and photographed. Burnt bone pieces from barrel number 2, the human bones were removed from the rest of the contents and photographed. 6200, teeth, property tag 6197, suspected bone fragments and separated human bone was removed. And 8118, suspected bone fragments, the separated human bones were removed and photographed. And 8148, bone fragments, the separated human bone fragments were removed and photographed. 8150, teeth was removed and photographed. And 8140, bone fragments, the separated human bone fragments were removed and photographed. And then we've got the ones from the quarry park, from the Manitowoc County gravel pit area. 7411, 7412, 7414, 7416, 7419, 7420, 7421, 7246, 7426, 7434. After all bone fragments that were determined to be able to return to the Holbachs by attorney Fallon and attorney Ghan. So yeah, let's make it clear. Were determined by Fallon and Ghan, were completed. The items were transferred to the Whiting Funeral Home in the presence of Mark Wiegert and Deputy Hawkins. The packaging for all the items returned was retained by Calumet County Sheriff's Department. Okay, let's see how we're doing. That's better. Let's go rid of that. Okay, one more little bit that I wanted to run by, because again I think it's useful to have a look at. Malcontents, legal, political, campaign news, analysis, Wisconsin election law news, Stephen Avery versus Wisconsin updates. This was June the 1st, 2019. So what have we got here? We've got Wisconsin evidence preservation law fails when DOJ and other cops dismiss duties mandated by the state, Madison, Wisconsin. As a Wisconsin Circuit Court judge, Sheboygan County Judge Angela Sukrevich, substituting, works on crafting her opinion to sabotage the post-conviction litigation of an innocent man. A state law meant to preserve evidence is one focus of legal filings this year by wrongful conviction attorney Kathleen Zellner. So as it says here, Wisconsin's biological evidence preservation law is clear. Quote, except as provided in subsection 3, if physical evidence that is in the possession of a law enforcement agency includes any biological material that was collected in connection with a criminal investigation that resulted in a criminal conviction, delinquency adjudication, or commitments under various statutes, and the biological material is from a victim of the offence that was the subject of the criminal investigation or may reasonably be used to incriminate or exculpate any person for the offence, the law enforcement agency shall preserve the physical evidence until every person in custody as a result of the conviction, adjudication, or commitment has reached his or her discharge date. So let's carry on down, see what we've got. The case is State versus Stephen Avery, appeal number 2017 AP002288, brought by Stephen Avery, featured in the Emmy award-winning Making a Murder. The prosecution, led by Wisconsin Attorney General Josh Cole and his legal team, including Mark Williams, Assistant Attorney General and Special Prosecutor Tom Fallon, and Special Prosecutor Norm Ghan, have not challenged the fact that law enforcement destroyed evidence in violation of state statute. In fact, Department of Justice Special Prosecutors Tom Fallon and Norm Ghan plotted to destroy evidence in 2011, and now Attorney General Josh Cole has both Fallon and Ghan defending the wrongful prosecution of Avery, discredited work of the disgraced sex offender and ex-Calumet County District Attorney Ken Kratz, who foisted a fraud upon two separate juries, arguing two conflicting sets of facts to convict both Stephen Avery and Brendan Dassey. This is a bizarre development in which two DOJ attorneys break the law, represent the state in post-conviction litigation, and then refuse to engage the arguments, pleading the facts and implications of their unlawful conduct. The legal strategy of the state protecting the conviction of a man whom they know to be innocent is to present a serpentine, internally inconsistent procedural argument that does not address the merits of the willful and unlawful destruction of evidence and the due process implications of this lawless state action committed in 2011. Worse, the state DOJ is continuing its effort to obstruct Attorney Zellner, while Judge Suckrich continues her strategy of running legal interference on the circuit court level, to whom the case was sent back by a state appellate court on February 25th, 2019. This is a spectacle of lawless Wisconsin law enforcement that is largely blacked out in the Wisconsin media. And I couldn't agree more with malcontents. They just don't want to hear about it. As Amelia McDonald Parry reports in Rolling Stone magazine in February 2019, Attorney Kathleen Zellner has filed a new letter with the Wisconsin Court of Appeals on behalf of her client, Stephen Avery, accusing the Attorney General's office of trying to deceive her and the court about the status of key forensic evidence in the Making a Murderer case. Zellner's letter, submitted on February the 13th, which we will get to at some point, is actually her second letter to the court in as many days. Both letters supplement a January 24th motion that accused prosecutors of violating state law and Avery's constitutional rights by destroying evidence. Zellner tells Rolling Stone that she has since learned that a key piece of evidence, suspected human pelvic bone fragments, which could exonerate her client, may have been destroyed as well. And she says prosecutors are obstructing her efforts to find out. According to a newly discovered police report and updated evidence control ledgers on September the 20th, 2011, human bone fragments recovered during the investigation were removed from the Calumet County Sheriff's Department Evidence Control Unit. They were transferred to a local funeral home, which then returned the bones to the family of murder victim Teresa Holbach. According to an affidavit from Steve's former appellate attorney, Suzanne Hagopian, the state never informed defense counsel of its intention to effectively destroy key case evidence by giving it to the victim's family. Wisconsin law requires law enforcement to preserve any biological material and physical evidence until the convicted defendant has been discharged from prison. Avery is serving a life sentence without the possibility of parole, and the Wisconsin statute protects his right to retain evidence that may reasonably be used to incriminate or exculpate any person in Teresa's murder. Calumet County Sheriff's Department Deputy Jeremy Hawkins states in his 2011 report that Sergeant Investigator at the time, now Sheriff, Mark Wiegert, and attorneys Tom Fallon, Crater Face, and Norm Ghan, Robot Voice, were involved in removing the bones from evidence control. Wiegert was a lead investigator in the case, while Fallon and Ghan were on the trial prosecution team. Fallon is now an assistant attorney general, and he and Ghan continue to represent the case on behalf of the state of Wisconsin as Avery appeals his conviction. Rolling Stone sent Fallon and Ghan a detailed request for comment on the claims outlined in Zellner's court filings. A spokesperson for the Attorney General's office replied to say that they cannot comment on ongoing litigation. The September the 20th, 2011 police report, which Zellner says she received in December from an anonymous third party, I think we know that was a certain Aussie lady, has exposed a lot more than just a violation of state law. A thorough assessment of updated evidence control ledgers and crime lab unit reports attached as exhibits to her four most recent court filings and reviewed by Rolling Stone indicates that the human bones recovered during the investigation were more plentiful than had ever been conveyed to the defense. And many of the bones that were returned to the Holbach family in 2011 were collected from locations that prosecutors claimed had nothing to do with her murder. According to police and prosecutors, Stephen fatally shot Holbach in his garage, dismembered and then burned her body in a pit next to his trailer. Investigators recovered charred human remains, namely bone from Avery's burn pit and a burn barrel. However, there is also evidence of a second burn location just over half a mile from Avery's trailer. The Manitowoc County quarry is about a quarter of a mile from what used to be a back entrance to the salvage yard. That's where investigators recovered another burn pile containing possible human pelvic bone fragments. Steve's trial attorneys theorized that the quarry bones were evidence that Holbach Teresa's body was burned somewhere other than Steve's property. Sweaty, on the other hand, downplayed the possibility that they were human, telling the jury, "These bones in the quarry, I'm going to take 20 seconds to talk about, because the best anyone can say is that they are possible human." KZ has wanted to get her hands on the suspected human pelvic bones since November 2016, when the Wisconsin Circuit Court ordered new scientific testing on certain items of evidence. In September 2017, Assistant Attorney General Fallon agreed to allow a microscopic examination of the pelvic bone fragments to determine whether they're human. For KZ, this examination is just the first step toward proving a long-time defense theory that Teresa was killed, dismembered, and burned at another location. Steve's lawyer, Jerry Buting, even said, if her body parts are over in the quarry, then Stephen Avery's innocent, because the prosecution said she never left the property, Zona says. Plus, he's not going to bring the bones from the quarry and plant them in his burn pit. However, soon after the parties agreed to examine the bones, the Circuit Court, Angela Sukovich, issued a seemingly hasty decision denying Avery's petition for post-conviction relief, despite the fact that several court-ordered tests were still pending. Examining the bones has been put on hold pending a ruling by the Court of Appeal. State Appellate Court will make Stephen Avery free, observers believe. What is unclear at this point in litigation is how far Wisconsin law enforcement, led by Wisconsin's Attorney General Josh Cole, will go to protect an unlawful and wrongful conviction. When will they let go of that balloon? Okay, who have we all got with us today? Alice, iced coffee. Linda, not my verbiage. Dark side. T1, hi there. Sean, hi Sean. Dark side. Kelly, Jay. All the usual suspects are here by the looks of it. Shane Henry, hi there. Okay, I think that's everybody that's and Gloria, hi Gloria. Well, and Disco Pervert, hi there. Well, thank you all for popping in. I say it's over a year old, this stuff, but it's still worth going over it and just reminding ourselves over and over again what the hell have Wiegert, Ghan, and Fallon gone and done. It's never happened before in Wisconsin. There's never been a case like this. Let's hope that the punishment for the three of them will be the most severe that they can possibly get. I'm going to say cheerio. As I say, tomorrow evening about 8 o'clock, a live chat with Sharon Sunshine about she's put together 24 hours worth of Ericose videos. So that'll be good. And I'll say next weekend, Tracy Keogh has agreed to come back and have another chat with me, as it's about the anniversary of Brendan's petition for clemency. And of course, Monday, regular chat with Dr. Siltman from Adelaide, who won't be too happy that the Port Adelaide are doing quite well at the moment still. And hopefully catch up with the the hillbilly from Milwaukee, Millbilly at some point as well. Okay, we'll catch you all then. Bye for now. Cheerio.